Welcome back everybody to the Law of Tort. In this video what we're going to be doing is talking about the concept of negligent misstatement, which relates tangentially to the concept of pure economic loss and consequential economic loss. We'll take an introduction to negligent misstatement in this video, and then we'll talk about some of the implications of negligent misstatement in the next few lessons as well. So far, we've been discussing the nature of pure economic loss, as well as the distinction that is often made between pure and consequential economic loss, noting that there is actually quite a difficult delineation to be made between these two concepts. In this lesson, like I said, we're going to start to look at the concept of negligent misstatement in more detail. So, the question for us today is essentially, what is negligent misstatement? What do we mean when we talk about negligent misstatement? Well, what negligent misstatement refers to is a situation where a defendant negligently will make a claim or a statement to a defendant, and then for that defendant to then rely upon that statement in which the falsehood leads to a pure economic loss. So, for example, if I rely on somebody's statement when I make a claim, and my reliance on this statement is pending on money that I put down, or potentially a loss of money if that statement is wrong, and the defendant has been negligent in making this claim and this statement, and it turns out to actually be false, then, and as a result of which I suffer some kind of economic loss, then this would represent a type of negligent misstatement. While the general rule is that there is no valid claim for pure economic loss, generally speaking, the concept of negligent misstatement represents something of an exception to this rule, because in reality, negligent misstatement represents a pure economic loss. It is an economic loss on the basis of a false claim that is made, but it is still a valid claim within the law of tort. The case of Hedley Byrne and Heller from 1964 is the case where we discuss negligent misstatement in more detail. In this case, you have the claimants. The claimants were an advertising agency. They essentially wanted to see and inquire about a potential client, and the potential client was Easy Power, and so as a result of which they wanted to know if their potential client was credit worthy. I.e., were they able to essentially be able to, would they be able to pay their dues, or were they essentially a good client to have as an advertising agency? Would they make the advertising agency any kind of money? They tried to get information about the potential creditworthiness of the Easy Power company from the bank of the client, from the bank of Easy Power, and so as a result of which the bank were the defendants. The bank would then respond by saying that the Easy Power company had favorable credit reference. They had favorable credit, and this incentivized the claimants to enter into a contract with Easy Power and take them on as a client as part of their advertising agency. When the Easy Power company then went into liquidation a few months later, the claimants lost around £15,000. They then sued the bank for negligence in terms of the statements that they had made, for negligent misstatement. It was held that the defendant was not liable in negligence, but it's a little bit more complicated than this, because they were not liable in negligence as the result of one particular action that the bank did, but if they had not performed this action, they would have actually been liable in negligence. The reason why they were not liable in negligence was because when the bank had been approached for this information, upon request for the information about the creditworthiness, the bank actually included a disclaimer that said, quote, "for your private use and without responsibility on the part of this bank or its officials." This represents a disclaimer. They essentially said, this is the information that we have upon on the idea of this company's creditworthiness, but we do not take responsibility for any of the things that you do in response to and upon given this information. The argument that the House of Lords presented was that essentially, but for the issuance of this disclaimer, the bank would have actually been negligent for a statement made. So all the parts, all of the key components of negligent misstatement existed in this case. They were all present in this case. The only thing that stopped them from being liable in tort was the fact that they had issued a disclaimer. Now, today, with statutory regulation and consumer protection legislation, disclaimers like this wouldn't have been as as strong in terms of the protections that they give, but at least at the time, they worked particularly well. And so essentially what we have here is the establishment of a negligent misstatement and all the key component parts of the negligent misstatement, despite the fact that the claimants were, the defendants, were found to have been not liable in the law of tort, owing to a particular niche element of the case. What is interesting here is it essentially delineates from the principles that we see when we look at the duty of care, i.e. the case of Donahue and Stevenson, because in addition to these principles, it is recognized that the concept of proximity that we see in other duty of care cases, in other negligence cases, this idea of proximity can be translated in these kinds of cases to include issues where there is a special relationship that is established between the claimant and the defendant. And so all of these issues are raised and discussed, but it doesn't mean they don't apply to the case of Hedley Byrne. The only thing that is different about Hedley Byrne is the issuance of this disclaimer that existed. And so a special relationship standard can exist between a claimant and a defendant such that a negligent misstatement can actually give rise to liability, and so really represents a pure economic loss and an exception to the general rule that pure economic loss does not often give us a valid claim.